Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. If you were just with me on my last stream, we went over that footage from the hotel where Blake Lively was alleged to have harassed a fan or a creator, whatever you want to call it. And then I said I was going to pack it in for the night, go to bed. And then here we are now because there's a new filing in the Justin Baldoni versus Blake Lively legal universe. This is again relating to the New York Times, however. So the Times and Blake Lively's publicist, Leslie Sloan and Vision PR, these are two separate parties. So here's Sloan, okay, and here's the Times. Sloan submitted their motion to dismiss first. And then Justin wrote back to that. Justin's side wrote back to that. And then yesterday, I believe it was, we went over that. It was yesterday. We went over where Sloan had filed an extra support of her motion to dismiss. So the Times, then they did a little bit after Sloan had tried to dismiss from their side. The Times, filed their motion to dismiss Justin's complaint. It couldn't have been that long ago. It must have been a couple weeks. And now this is Justin responding to the Times. So this has nothing to do with the publicist lawsuit. We went over that yesterday, and this is a separate kind of, it's all combined. This whole thing is like combined on the docket, but this is a separate party that's moving to dismiss. So already the judge just made a ruling. So the judge's ruling yesterday was in regards to the protective order, which is something that'll be relative in like what's publicly available, like what the public can see and stuff. But this is actually like not at all relevant to that because this is just like the New York Times wants to dismiss the complaint. They want out of the lawsuit, and the Wayfair parties are now going to tell us why that should not happen, and they're going to ask, I think, for leave to amend. That means they would post a second amended complaint and try to strengthen their case. So we'll go over that together. Thanks everyone for being here. I appreciate it. 1 second. Yeah, I finished that last stream and I went downstairs and I was like, well, that's it. I'm done for the night and I was going to make dinner. And then this came up and I decided to be an adult and I shoved a protein bar in my mouth and decided I had other things to do. So it'll be good though. Hello. Thank you, Helene, for the $20. I appreciate it. I appreciate that. Okay. Wow, we're starting out with a language already. Okay. A pietistic bastion of the media establishment. I don't know if I said that word right, guys. The New York Times has long presumed itself beyond accountability. Not here. I like this so far. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department complaint and actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability for maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair parties, wrongly casting them as villains and making them scapegoats for Lively's well-publicized media missteps. On December 21st, 2024, the New York Times published a story titled "We Can Bury Anyone: Inside a Hollywood Smear Machine," and a related video featuring New York Times journalist Megan Twohey, who co-wrote the article along with Mike McIntyre and Julie Tate, purporting to tell the world what really happened, specifically that the Wayfair parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film. The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties. So they're saying they didn't just repeat it, they made it sound worse about the Wayfair parties and falsely accused them of having waged a smear campaign against Lively. The press enjoys the fair report privilege when faithfully relaying the contents of a filed complaint, but that is not what the New York Times did. It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation. In doing so, the New York Times forfeited the fair report privilege. The New York Times prepared its salacious article and video well before TUI contacted the Wayfair parties the night before publication for fact-checking. After the New York Times' months of plotting with the Lively parties, the Wayfair parties got hours to respond. And as Brian Friedman pointed out in that podcast that was posted yesterday, most of the hours that they had to respond were sleeping hours, like any normal person, well, not me maybe, but any normal person would be sleeping during those hours. So. Roses Wild says, I thought when Brian was talking a few days ago, I thought he said they colluded for at least 5 months, which meant it was before October. I don't know. I'll have to look into that after. 1 sec. All right. The New York Times prepared its... Yeah, we got hours to respond. Okay. The New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfarer parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties. A jury will determine the truth based on the evidence, but the Wayfarer parties' allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfarer parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California, which has a strong interest in protecting its citizens. The New York-based New York Times insists it is entitled to New York law no matter where their harm was felt, but California law remedies harm suffered in California by California residents. Under either California or New York law, the Wayfarer parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report privilege. Yet in the same breath, the New York Times also insists that its defamatory statements are not factual at all, but rather hyperbolic, non-actionable opinion. Neither theory holds up. The First Amended Complaint, or FAC, also states claims for false light, promissory fraud, and breach of implied in fact contract. Even if the motion is granted, it should be granted only with leave to amend. Federal courts apply an extremely liberal policy of amendment under Federal Rule of Civil Procedure 15. The Wayfarer party's claims against the New York Times are well grounded in fact and law. In addition, based on their own continued investigation and on facts drawn to their attention, the Wayfarer parties have obtained additional information since filing the FAC that would enable them to plead further facts in support of their claims. This dispute should be resolved by a jury trial. And then here's a footnote here, and that was relating to the fact-checking that they mentioned, like the thousands of texts or whatever. And the footnote says, while the New York Times baselessly claims in the motion that the FAC's allegations regarding the metadata associated with the article and video are wrong, a Rule 12b6 motion to dismiss is not a proper venue to raise factual disputes. The New York Times does this repeatedly throughout its motion. All right, here we have the relevant background. Wayfair acquired the film rights to Colleen Hoover's novel It Ends With Us in 2019. Justin Baldoni took on the role of director as well as male lead character Ryle. On December 31st, Lively agreed to take on the lead role of Lily Bloom. It initially appeared that Baldoni and Lively would have a productive working relationship as they collaborated closely in the production's early days. However, Lively soon began intruding into the production in ways well beyond the scope of her contractual entitlements. At one point, Lively issued an ultimatum that if Baldoni could not get on board with her work methods, he may have to recast her role. I wish they would have. I know that's devastating to the movie, but I wish they would have. On November 9th, Lively's lawyer sent an unexpected and confusing 17-point list of non-negotiable demands that had to be met before Lively would return to work following the SAG-AFTRA strike, apparently drafted for the purpose of falsely insinuating that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. While the Wayfarer parties disputed that Lively's demands had any legitimate predicate, they nevertheless found that the requests largely unobjectionable, sorry, and generally consistent with existing practices. Filming proceeded thereafter uneventfully through the second phase of production without any further purported incidents of which Lively could complain. However, Lively exploited her carefully constructed paper trail of false insinuations to complete a hostile takeover of the film based on the implicit threat that she would ruin the Wayfarer party's careers and reputations. Gradually, Lively took over the film's editing, ultimately extorting Sony and Wayfarer into releasing her cut despite its poor performance in audience tests. She also dictated the film's marketing, erasing Baldoni and driving from a lighthearted, frothy, self-involved promotional campaign, which resulted in harsh blowback from the press and by the public, who viewed Lively's marketing as tacky and tone-deaf. Hold on. I have to wear these or I get headaches if I stare at the screen for too long. And Lord knows I've been doing that lately. Thank you, user 5877. I appreciate that. All right. As the premiere of the film approached, Lively told Sony that she and the rest of the cast would not participate in any marketing or promotion alongside Baldoni, deliberately creating the false impression that Baldoni had committed some serious offense. On information and belief, Sloan was throughout this time working to spread false and defamatory allegations against the Wayfarer parties to members of the press. Okay. The Wayfarer parties finally stood up to Lively and Reynolds and refused their final demand that the Wayfarer parties put out a false and humiliating statement admitting wrongdoing. In response, Lively and the Sloan parties worked with the New York Times to concoct a story that would blame Lively's downfall on the Wayfarer parties, relying heavily on deceptively spliced private text messages stolen from Abel's phone by her former employer, and Baldoni and Wayfarer's former publicist Stephanie Jones of JonesWorks LLC. The New York Times coordinated its publication with Lively's filing of the otherwise confidential CRD complaint on December 20th. As a direct result, the Wayfarer parties have suffered untold harm. The article states that during production of the film, Lively had complained that Heath and Baldoni had repeatedly violated physical boundaries and made sexual and other inappropriate comments to her. The article continues, the documents show an additional playbook for waging a largely undetectable smear campaign in the digital era. As admitted in the article, the New York Times relied not just on the CRD complaint itself for its reporting, but on thousands of pages of documents that the New York Times reviewed. The video likewise confirms the New York Times statements were based on private text messages and other documents that the New York Times obtained that reveal what really happened. And then they included a transcript of the video in the second document that I have here. So we'll go through that after this. The video and the article both state that the Wayfarer parties engaged in a smear campaign against Lively, with the video proclaiming, it's impossible to know how much the Wayfarer parties planted and how much of it was originating organically. Whatever the case, they seized on it and amplified it. In sum, as detailed in the First Amendment complaint, the New York Times published an article and video advancing a factually false and defamatory narrative about the Wayfarer parties based on deceptively spliced and cherry-picked text messages. Now, it must answer to them. Sorry, just like that. Okay. Give me just a second here, guys. Sorry, I received some complaints that the ice in my giant water bottle was very loud against the microphone, so I have to stop and pause for that. All right. Legal standard says under Rule 12b6 of the Federal Rules of Civil Procedure, a plaintiff must state enough facts to state a claim to relief that it is plausible on its face. The claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. In ruling on a motion to dismiss, the court must accept the factual allegations as true, drawing all reasonable inferences in favor of the plaintiff. Okay. Here's the argument. Number one, the New York Times has ample notice of its actionable conduct. Rule 8 of the Federal Rules of Civil Procedure imposes a lenient standard for pleading. Under Rule 8, a pleading need only contain a short and plain statement of the claim, showing that the pleader is entitled to relief. And then they're citing the FRCP here. Specific facts are not necessary. The pleading need only give the defendant fair notice of what the claim is and the grounds upon which it rests. Okay. The Second Circuit has noted that Rule 8 does not necessarily require that the complaint separate out claims against individual defendants. Okay, interesting. Nothing in Rule 8 prohibits collectively referring to multiple defendants, but the complaint alerts defendants that identical claims are asserted against each defendant. The FAC gives the New York Times adequate notice of the claims against it. The FAC alleges that the New York Times conspired with Lively, Reynolds, Sloan, and Vision PR to advance a false and defamatory narrative concerning the Wayfair parties, ultimately coordinating a near simultaneous drop of the article, video, and CRD complaint. The allegations in these three documents fall into two principal categories. Okay. One, allegations that certain of the Wayfair parties engaged in sexual misconduct towards Lively. And two, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she purportedly reported their alleged misconduct. Those allegations are false, and the New York Times either knew they were false or acted with reckless disregard as to their falsity. To the extent the New York Times is grouped in parts of the First Amendment complaint with other consolidated defendants, that is because, as alleged in the FAC, they conspired in secret over a matter of months. The precise contours of the New York Times involvement were carefully concealed and impossible to ascertain fully without discovery. And remember, the judge had granted their motion to stay discovery, so like they paused discovery, so until he kind of decides on whether or not this is going to be dismissed. So they're saying here that they can't like fully ascertain what happened without the discovery. So YLM says no one trusts MSM. They're not journalists. They're hitmen writing hit pieces to assassinate character. That's why people are turning to independent creators. Man, I gotcha. Sometimes I'll take the overarching premise from these things and then I'll kind of dig into a little more. But like, is this part really true? Is this part really true? You know what I mean? And then also I wanted to point out, Sarah says, I love this community, and I wanted to thank you all for being here because it's been really cool to have everyone. So thank you for the $5, Sarah. Professor Lauren has entered the chat. Professor Lauren. But, you know, cool. All right. The FAC alleges that the New York Times participated actively in the legal maneuvering at the heart of Lively's strategy, and with an articulated basis in fact, that the coordination began as early as October 31st. Okay. And the First Amendment complaint noting references in the article's HTML source code to October 31st, 2024, and alleging that the New York Times had already begun building the article no later than that date. The cases cited by the New York Times are inapposite. The eCheck.com LLC versus NEMC FinServes, I don't know what that is, Financial Services Group, I think, concerns motions for entry of default judgment where the plaintiff failed to differentiate between defendants and attributed no specific conduct to any of them individually. Similarly, the pleadings at issue in Komatsu versus City of New York raised approximately 200 claims against 125 defendants, spread across 1,713 pages. Any lack of differentiation in the FAC does not rise nearly to those extremes. Okay. Sarah licked the like button. Wow. Anyways, Sarah, can you do me a favor and go over to Omar's stream right now and ask him if he wants to cover this on his stream when I'm done here, because I can join him for that if he wants. You got to spam his comments. He doesn't look at them. Also, Lauren is looking extra hot in them glasses. Guys, I've had so many people like spam messaging me. Like they're all these like Amber Heard and Blake Lively and Taylor Swift enthusiasts. And I'm like, dude, I didn't even say anything bad about Taylor Swift. And they're just like messaging me shit like, look at your chins and all that stuff. You mean these chins? Like, shut up. I don't care if anyone thinks I'm objectively attractive or not, because I don't want to talk to them. So it doesn't matter. Okay. But thank you for the compliment, I suppose, young lady. All right. Did we get through this last? I think we did, yeah. California law applies to the Wayfair party's claims. In diversity cases, federal courts apply the choice of law rules of the forum state. The choice of law rules of New York therefore apply. The first step is to evaluate conflicts between New York and California law. A conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly. Here, there exists substantive conflicts between the laws of New York and California as to the Wayfair party's claims against the New York Times. As to false light invasion of privacy, the conflict between the two states' laws is total. California recognizes the claim, while New York does not. Okay. Sorry, I was reading the footnotes to see if I needed to read that out loud. There are also important differences with respect to the defamation claim. For example, with respect to defamation, California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. Because there is a substantive conflict between the laws of New York and California as to the Wayfair party's claims, the court must analyze whether to apply New York or California law. In defamation cases, New York applies the law of the state with the most significant interest in the litigation. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. Okay. Although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the parties' domiciles and the locus of the tort. The interest of a state in a defamation action is significant and incontrovertible where the plaintiffs are citizens of that state and live and conduct their business there. Okay. Sunshine, thank you. Sunshine is reminding you to like this video or Blake will subpoena you. Oh, man. Okay. Let me make sure I got to all these star chats. Yes, I did. Okay. I actually love the sound of the ice when you drink your water. It sounds refreshing and makes me want to get a drink of water myself, too. Man, I'll have to do like a little ASMR water video. I just shake the ice. But not today. Right? Okay. In this case, California has a significant interest because nearly all of the plaintiffs are residents of California. The two corporate plaintiffs are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were all felt in California. Okay. Here, each of the Wayfair parties lives, works, and or maintains social relationships in California, and the law of California should therefore apply. Moreover, as participants in Hollywood's entertainment industry, the beating heart of which is indisputably the state of California, the Wayfair party's reputations mattered most in California. The New York Times argues that New York law applies because the article emanated from New York, for example, entirely reported from and conceived in New York. However, the First Amendment complaint itself does not allege that the article is based on information provided in New York by individuals residing in New York to reporters in New York. And discovery will be needed to reveal, among other things, precisely where the New York Times reporting took place. Reporting in quotes. Furthermore, the FAC does not say, as the Wayfair parties do not yet know, where the content was uploaded or where the relevant server resided, much less that either event occurred in New York. To the extent the New York Times has attempted to introduce ostensible evidence via declaration of counsel about the article and videos purported in New York Nexus, consideration of such materials outside the pleadings is inappropriate on a motion to dismiss. Okay. 1 second. Anytime someone wants to send me a message, I'm like, please, no. No more trolls. Okay. It's not a troll. Don't worry. But I had to check because I'm expecting something from someone. All right. Even if, as the New York Times contends, its reporting and defamatory statements emanated from New York, we read that, right? Simply because the defendant issues its nationwide publication from its principal place of business in New York does not mean that courts should automatically apply New York law to the dispute. In Sackler, a case that they're citing, a plaintiff brought a defamation claim against the publisher of the New York Post, arising from the publication's misuse of the plaintiff's photo in an online article. The Sackler court explained that the New York choice of law principles point not to the act as the locus of the tort, but instead to the injury, which is the final element that would make the defendant liable. The Sackler court found that the defendant's nationwide publication of his photograph had the greatest effect, to the plaintiff. I think they mean, you're supposed to say effect, not affect, but they sound the same. So, to the plaintiff and his overall reputation in the state where he resides. This reasoning applies here, particularly given that the defamatory statements were published primarily via the internet. Okay. And they're citing another case here, Adelson. It says, it's quite foreseeable that the brunt of the reputational harm that results from internet-based defamation is most likely to be felt in the forum where the defamed individual lives, works, and maintains social relationships. And this is where they're, talking about a lot of the legal stuff here. So there's going to be stuff that Omar or another law tuber will explain better than me, but I'm going to, oh my goodness, my phone's doing that. Sorry about that. That Omar or one of the other law tubers will explain better than me, but we're going to read through it anyways, because why not? So if you guys just came in, thanks for joining us. This is a new filing. Justin Baldoni and Wayfair, etc., have submitted a letter in opposition to the New York Times motion to dismiss. So we're going through that right now. All right. Okay. Let's go through that. Two cases the New York Times discusses and relies on, Jacob and Kingsley, are inapplicable. The courts in both those cases noted that the defamation claims emanated from New York. Okay, went through that. Here, other than alleging the New York Times is a corporation with a principal place of business in New York, the FIC is silent on where New York Times reporting took place and where the article and video emanated from. Regardless, California has a far more powerful interest in the application of its law than the states at issue in Jacob and Kingsley, because this case involves not only California residents, but also Hollywood's entertainment industry. We read that already. Lauren, why don't you... Sorry, guys. I get lost sometimes because of my whole ADD brain. Anyways, the article is also purportedly based on reporting concerning Lively CRD complaint filed in California, which purported to assert claims under California's employment and labor laws. The New York Times also glosses over the fact that filming took place not in New York, but in New Jersey, which is where Lively alleges most of the events took place. In short, the laws of California can and should supply the remedy for harm suffered primarily in California by plaintiffs who all live, work, and or do business in California, resulting from conduct aimed at California, all in connection with the entertainment industry centered in California. Okay. And here in point 3, they're going to argue why the Wayfair party's claims should not be dismissed. A is the defamation claim should not be dismissed. Yeah, these glasses are getting foggy. I'm going to ask you guys to give me 1 second. Okay? It'll be like 10 seconds, actually. I'll be right back. Okay. I did something strange to try to clear the fog out of my glasses, and I didn't want anyone to have a chance to record that. So, okay. Anyways, California recognizes 2 types of libel, per se and per quad. A statement is libel per se when it is defamatory of the plaintiff without the necessity of explanatory matter, such as inducement, innuendo, or other extrinsic fact. Whether a publication is libelous on its face is a question of law. The publication is to be measured not so much by its effect when subjected to the critical analysis of a mind trained in the law, but by the natural and probable effect upon the mind of the avenged average reader. I mean, either one works fine there, right? A defendant is liable for what is insinuated as well as for what is stated explicitly. False allegations of sexual misconduct are defamatory per se. The crux of the article and video is that the Wayfair parties engaged in and or condoned sexual misconduct and took revenge on the victim of such misconduct. These allegations tend to expose the Wayfair parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of right-thinking persons. They don't mean right as in political, by the way, guys. They mean right like sane, I guess. To deprive them of friendly intercourse in society. As to it ends with us and Wayfair, it is well settled that a statement that impugns the basic integrity of a business is per se defamatory. And contrary to the New York Times, it is clear that the defamatory statements made by the New York Times in the article and video were of and concerning each of the Wayfair parties, either directly by implication, and all have become, I think they mean or by implication, and all have become figures, of infamy as a direct result. Let me skim through these footnotes real quick. Okay, we'll go for that. Because this is not a case in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfair parties, the New York Times is raising a question of fact for the jury and not a question of law for the court. Okay. All right. Number one, the fair report privilege does not apply to protect the New York Times. Okay. This is the second time here. What do you mean? Oh, no notifications. Yeah, YouTube notifications are notoriously bad. They always have been. All right. For the fair report privilege to apply under California law, the publication at issue must, 1, report on the contents of a judicial or other public proceeding, 2, be a fair and true report of the proceeding, and 3, be published in or made to a public journal. A publication is fair and true only if it captures the substance of the proceeding as measured by the natural and probable effect on the mind of the average reader. A report is not fair and true if the publication is stupid. Sorry, that's not what they wrote there. I just had to interject. Okay. Hold on. Okay. A report is not fair and true if the publication deviates from the judicial proceeding such that it produces a different effect on the reader than the actual truth of the proceeding. Here, the privilege can apply only if the effect on the readers and listeners of the article and video would have been substantially the same as the effect on the readers of the CRD complaint itself. Okay. And then this footnote 12 says, although the New York Times now argues its statements did not implicate Sarowitz, it is telling that Tui reached out to him for comment, along with the other Wayfair parties before publication. She clearly was not of the belief that the article and video did not implicate him personally. Interesting. All right. That's a fair point, yeah? I think so. Okay. Ulysses, I didn't hear any eyes. Sorry, it melted, dude. I don't know what to tell you. Okay. In the article and video, the New York Times offers its own commentary that goes well beyond merely reporting on the CRD complaint and therefore falls outside the scope of the privilege. Okay. For example, in both the article and video, the New York Times presented as unquestioned fact the false and defamatory claim that the Wayfair parties orchestrated a smear campaign. The New York Times cites to thousands of pages of documents it had reviewed and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing of which Lively accused them. And again, this is from the video transcript, which we'll take a skim at when we're done reading through this filing. These extraneous comments and defamatory allegations, at least one of which the New York Times admits was not taken from the CRD complaint, are not a report of the CRD complaint and undoubtedly would produce a different effect on the reader than would the CRD complaint. Thus, they fall outside the bounds of California's fair report privilege. Holding fair report privilege, and they're citing another case here. Holding fair report privilege did not apply to the portions of the defendant's video that consisted of tangential commentary, since it deviated substantially from reporting on his counterclaim and produced a different effect. And they're talking about, what is that, Goldberg? That's going to be another thing for the law tubers, guys. You know me, I'm the random opinion, not the lawyer opinion. Okay, the New York Times vouched for Lively's allegations by affirming that its reporter's independent investigation supported her claims and thus lost the protection of the fair report privilege. Whether the New York Times publications are fair and true accounts of the CRD complaint are questions of fact that cannot be resolved at this stage. And then they're saying, see Pierce v. San Jose, whereas here reasonable minds could disagree on what is fair. The issue is a question of fact to be determined by the jury. Number 2, the New York Times statements are not constitutionally protected opinions. Here we go. We got lots of footnotes at the bottom here, guys, but they're all relating to like specific cases. And I feel like, again, that's going to be something that's more appropriately addressed in a law tuber stream, not me. So we'll just get into the rest of it. Under California law, to constitute defamation, the offensive publication must consist of statements of fact, not opinion. A statement is defamatory only if it is capable of being proved true or false. Okay. And then they're citing a case here. Statements do not imply a provably false factual assertion and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts. But expressions of opinion often imply assertions of fact and are therefore actionable. Thus, a statement in the form of an opinion may be actionable if it is implied that it is based on some undisclosed defamatory facts. The issue of whether the statement is fact or opinion is one for the jury. Slaughter v. Friedman. That's Slaughter. I wish my last name was Slaughter. I know it's probably pronounced Slater, but still. Okay. This is the kind of intellectual discourse you guys come to my stream for. Just saying. The dispositive question is whether a reasonable fact finder could conclude that the published statements imply a provably false assertion of fact. To answer that question, the court applies a totality of the circumstances test and reviews the language of the statement and the context in which the statement was made. Here, the New York Times made statements that the Wayfair parties engaged in, permitted, and or failed to prevent sexual misconduct and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure thereof. Furthermore, the New York Times asserted not only that the Wayfair parties engaged in a smear campaign, but also stated in the article's title that the Wayfair parties operated or were a part of a Hollywood smear machine. The New York Times assertion that the Wayfair parties operated a smear machine that waged a smear campaign was a factual statement that went beyond even Lively's allegations in the CRD complaint, which does not contain these phrases. And if anybody has trouble finding that CRD complaint, accessing the CRD complaint, it's not a public document. But Jed Wallace, who filed a federal case in Texas against Blake Lively, he included her CRD complaint, her precursor, everything in his exhibits when he filed his lawsuit. So that's how you can see that. So if you want to fact check against the CRD complaint, you can do it for free. Go to courtlistener.com, or you can find it on my Patreon page. I post most of the documents there. And it's for free. You don't have to pay for that. All right. The article claimed to expose the existence of a hidden, nefarious machine devised by the Wayfair parties that wages undetectable smear campaigns to destroy its enemies. The New York Times statements imply misconduct on a scale larger than that at issue in the CRD complaint and are not immune from suit as opinion. The article's false assertion of a smear campaign. I keep checking back at my StreamYard screen, guys, and going away from the document because I have this mild little, I don't know, what do you call it? It's not a daydream, but a day nightmare where I'm muted the entire time I'm talking on the stream. Sorry. I just thought everyone needed to know that. All right, anyways, back to our regularly scheduled program. Blake Black's Law Dictionary defines the phrase, there's an actual definition of this, defines the phrase smear campaign as the deliberate telling and repetition of untrue or distorted stories about a person in order to make others lose respect for that person. The phrase is inherently factual in that it suggests that a person waging such a campaign is spreading stories that are untrue or distorted. The cases cited by the New York Times in their motion to dismiss are again entirely inapposite. In the Hampshire, in the New Hampshire case of Pease versus Telpubco, I don't know what that means. Something public corporation. A journalist brought a defamation claim arising from a letter to the editor in which the defendant prefaced two of his assertions with language such as, "I do feel," and coupled his statement of a journalistic smear with the epithet that the plaintiff was the holder of the title, "Journalistic Scum of the Earth." Whoa. I gotta go follow that guy. The Peace Court concluded that readers would interpret the writer's hyperbolic statements as opinion rather than as assertions of provable fact. None of the other cases cited by the Times involved smear accusations. In Dong versus Board of Trustees, the statements at issue were preceded by qualifying language that the assertions were merely a claim and that a peer committee should investigate. Okay. Like I said, I'm going to continue to skim over a little bit of this case law, but this paragraph right here has some interesting things in there, particularly in Greenbelt Co-op versus Bressler. The statement at issue was blackmail and not smear campaign, as the New York Times suggests. And in Chow versus Lewis, the defamatory statements were epithets such as sucker and fool. I find this interesting because I could say so much worse. And I'm just like, were these really the worst things that people could find? But yeah. All right. Something's annoying. What has it been? Doing something to you guys. Hang on. Oh, yeah. No, notifications are ass on YouTube. But and also YouTube, guys, YouTube deletes comments that like they don't even come to me. So like I have a modify or like not modification or like a held section to where I have to look through. Sorry, I got distracted by another comment. Where I have to look through comments and approve or deny them. But YouTube takes some comments and deletes them without my ever knowing and never seeing them or anything. And it started to do that with my own comments. So I had a pinned comment the other day regarding some like New York law and stuff where I had posted some links. And then it warned me about cyber harassment. And it deleted my comments. And it said, like, if you continue to do this, you might get a community violation or something. And I was like, are you kidding me? Like, what did I do wrong? So it was very strange. And I wasn't even talking to anybody. It was a pinned comment. Like, what? Kitty, got your tongue, Lauren, I normally lurk as my ADHD loves your shorts, but your reporting skills are undeniable. Kitty, you should see my pants. Okay. Okay. Anyways, the statements at issue here were made not in an editorial letter, but rather in an explosive feature-length expose reported by, among others, the New York Times Pulitzer Prize-winning star journalist, Tui, based on their own review of thousands of pages of text messages and emails. The New York Times statements in the article and video are not couched or qualified by equivocal language suggesting that the New York Times or TUI were expressing an opinion. They were presented as statements of fact based on first-hand knowledge of the evidence. In that context, a reasonable viewer would have interpreted the New York Times smear machine and smear campaign statements not as mere hyperbole, but instead as provable, verified assertions of fact. Statements of this nature are not shielded from suit as non-actionable opinion. So we'll go, like I said, we'll go over that transcript because Baldoni's team also filed the transcript of that video as an example here. But we're going to read through the rest of this filing first. We have 8 more pages of this. It's not bad. Not bad. Okay. Could be way worse. Let's put it that way. Okay. The New York Times statements state or simply imply that the Wayfair parties engaged in grossly immoral conduct to cover up even more grossly immoral conduct, and such statements resulted in the destruction of their reputations and careers. The statements by the New York Times cannot be, and were not, construed as mere statements of opinion or of hyperbole. they were false statements of fact. And if the court finds that the statements could be reasonably construed as either fact or opinion, the issue should be resolved by a jury, thereby warranting the denial of the motion. Number 3, actual malice has been pleaded against the New York Times. Okay. And then also there was a footnote here, guys, I want to read. To be clear, the allegations in the FAC are unequivocal that none of the Wayfair parties engaged in any kind of misconduct towards Lively. The Wayfair parties did not permit or fail to prevent any such misconduct, and the Wayfair parties did not orchestrate a smear campaign in retaliation for Lively's purported disclosures. The New York Times argues that Whoa, sorry, I just kicked my light by accident. That's what I get for being a YouTuber in my attic. The New York Times argues that the Wayfair parties have to satisfy the actual malice standard because of Baldoni's status as a public figure and New York's amended anti-SLAPP law. Though California and New York law diverge on whether the actual malice standard applies to all of the Wayfair parties, it is irrelevant for the present purposes because the FAC adequately alleges actual malice with respect to each of them. And there's a footnote here too, hang on. 19 says this is true despite the fact that 6 of the Wayfair parties are certainly not even limited public figures. Okay. To plead actual malice, a plaintiff must allege a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. While reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness or probable falsity or entertained serious doubts as to the truth of his publication. Construed as true, the FAC's allegations set forth plausible grounds to infer actual malice. Actual malice is subjective, but a court typically will infer actual malice from objective facts. This refers to evidence of negligence, motive, and intent, such an accumulation of the evidence and appropriate inferences supports the existence of actual malice. And they're citing a Bosworth there. Actual malice is established through the defendant's own actions or statements, the dubious nature of his sources, and the inherent improbability of the story, among other circumstantial evidence. Here, it is not just that the New York Times failed to adequately investigate, but rather that it did investigate and obtained and reviewed communications that disproved what it later published, and that it edited and spliced documents to mislead viewers. Willfully disregarding, let alone manipulating information, casting doubt on a story is altogether different from negligently failing to investigate in the first place. What are you talking about? They gave you like 3 hours to respond to their months of work. Where a publisher undertakes to investigate the accuracy of a story and learns facts casting doubt on the information contained therein, it may not ignore those doubts, even though it had no duty to conduct the investigation in the first place. And I don't know how to pronounce this last name. It's Mason versus New Yorker Magazine. So I'm just going to call it Mason. In Mason, for instance, the court noted that there was evidence from which a jury could infer that the New Yorker investigated the facts underlying the article, including the quotations, and that this investigation yielded information that gave the New Yorker obvious reasons to doubt the accuracy of the disputed quotations. Likewise, in Hart Hanks, the Supreme Court affirmed an actual malice finding where the newspaper refused to listen to recordings or interview witnesses denying the allegation. The New York Times admits it did undertake an investigation. As alleged in the First Amendment complaint, the New York Times made clear that the article and video were not merely recitations of Lively's CRD complaint, but were instead a work of independent investigative reporting. And that's possibly what could fuck them on this one, guys. So we'll see. One sec. Okay. I did not ask for a Shopify code. What's happening here? Okay. And they're citing the transcript again, which we'll go over, like I said. So. As alleged in the First Amendment complaint and conceded by the New York Times, the substance of the reporting was based on thousands of pages of text messages and emails, which, along with other documents, were reviewed by the New York Times. Armed with this voluminous evidence, the New York Times either knew or recklessly ignored proof that the contents of its article and video were factually false. The notion that Lively's bad press in August 2024 was actually caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. All right, then. There were obvious reasons to doubt the veracity of these statements. If you guys don't know what veracity means, it's like truthfulness or validity, basically, of these statements in light of the reporter's common sense. The New York Times prior reporting and the relevant primary source documents and communications that the New York Times obtained and that its reporters claim to have reviewed. Indeed, the New York Times itself reported on Lively's public missteps in August 17th article entitled "It Ends With Us, the Press Tour Drama Explained." Not only were the New York Times reporters privy to Lively's missteps in real time along with the world, they also reviewed private internal communications amongst the Wayfair parties directly refuting the article. Worse, the New York Times worked on the article for many weeks before publishing, yet the New York Times deliberately waited until the last possible moment to seek a response from the Wayfair parties. Awkward. Okay. And then footnote 21 here says, the New York Times argument concerning the FAC's purported failure to attribute actual malice to specific individuals is unavailing. The First Amendment complaint is laden with references to the article's principal author, Megan Twohey, and alleges that she and her co-authors, Mikey McIntyre and Julia Tate, knew that what they were publishing was false and or recklessly disregarded. Publishing was false and or recklessly disregarded the probability it was false by, at best, purposefully avoiding the truth. Purposely avoiding the truth. That's a good way to put it, yeah. Twohey herself is featured in the video. All right. Okay. The First Amendment complaint, it's cited there, I see, with the last line. All right. Indeed, on the evening of December 20th, Twohey contacted the Wayfair parties for a response by the next morning concerning explosive and false allegations. The Wayfair parties denied the allegations and specifically warned Twohey that her story was false and based on cherry-picked and context-free communications spliced into a provably false narrative. A publisher need not accept denials, however vehement, before publication. Hard hangs. Okay. But here, the New York Times could verify the denials because it had purportedly reviewed those communications. Purposeful avoidance of the truth supports a finding of actual malice. At this stage, the Wayfair parties have met their burden to plead facts, giving rise to the plausible inference that the New York Times published the allegedly defamatory article and video with actual malice. The test is whether the complaint is plausible, not whether it is less plausible than an alternative explanation. The jury may ultimately agree with the New York Times, but it is the jury that must decide. Guys. I mean, that I can kind of see why. Even if like everything the New York Times said to dismiss was like ultimately like the jury's not going to find that we did anything wrong. I agree. The jury should be the one to decide. So yeah. B, the false light and promissory fraud claim should not be dismissed. False light is a species of invasion of privacy based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. Okay. Under California law, the elements of promissory fraud action are 1, misrepresentation, 2, knowledge of falsity, 3, intent to defraud, 4, justifiable reliance, and 5, resulting damage. Promissory estoppel, I don't see that word very much, is a subspecies of the action and for fraud and deceit in which a defendant makes a promise, inducing the plaintiff to enter into a contract without the intention of keeping it. Here, on the evening of December 20th, the New York Times promised to delay until noon the next day so the Wayfair parties could respond to questions and inaccuracies. The Wayfair parties accepted the offer and tried to correct the record, albeit in the context of a brief overnight window of time during the holidays. Which, again, fuck y'all for that. I've heard, lawyers on certain channels say, like, this is just random, regular journalistic practice. And I think that's fucking nuts. Like, I think that's insane that people can just do that. Like, so you can say that it's not against the law, which is the whole point of my channel in the first place. It doesn't matter if it's not against the law. Sometimes people are just shitty. Just because you do something that's not illegal doesn't mean it's right. It doesn't mean it's okay. And it doesn't mean you're not a fucking scumbag. All right. Anyways, moving on. The Wayfair parties accepted the offer and tried to correct the record, albeit in the context of a brief overnight window of time during the holidays. As alleged in the First Amendment complaint, the New York Times outreach to the Wayfair parties was a ruse. The New York Times never intended the Wayfair parties to respond. The New York Times had already decided that the article and video would drop regardless of feedback from the Wayfair parties, as shown by the fact that both the article and video were ready to go at least days before the New York Times contacted the Wayfair parties. Indeed, although the Wayfair parties accepted the New York Times offer and scrambled to respond in just hours, the New York Times published early and without warning at 7:11 a.m. PST during the holidays at 7:11 in the morning. Like, I don't know, you can't tell me there was no, like, ill intention there. You can tell me maybe they didn't violate a law. I might, be open to arguments about that, but you can't tell me it wasn't shitty behavior. All right. And 23 here says, in a footnote, the New York Times argues that if California law applies, the false light claim should be dismissed because the false light claim is independently barred by California's fair report privilege. That argument fails for the same reasons as the New York Times challenge to the Wayfair party's defamation claim. Okay. The release of the false article and video damaged the Wayfair parties. The Wayfair parties' promissory fraud and implied contract claims cannot be dismissed as duplicative, and a claim for promissory fraud does not depend on whether a defendant's promise is ultimately enforceable as a contract. Towards the end of these documents, guys, I start to get all blah, blah. I'm not used to talking this much. As I've said a million times, I'm very introverted. I only talk to my dog. I'm just kidding. I do stuff, I promise. Hey, Taz, what's up? Lots of shitty behavior all around. Yes, there is. Yes, agreed. They are scum. Yeah. Okay. I'm going to skim over that because that's case-related stuff. Okay, C, the breach of implied in fact contract claim should not be dismissed. Got that. Under California law, a cause of action for breach of implied contract has the same elements as does a cause of action for breach of contract, except the promise is not expressed in words, but it is implied from the promisor's conduct. Here, the New York Times does not and cannot argue that the First Amendment complaint fails to properly allege the elements of a breach of implied in fact contract. Instead, the New York Times relies on certain outside the pleadings correspondence improperly introduced through its counsel's declaration to supposedly contradict the First Amendment complaint's allegations. The New York Times' attempt to raise and determine issues of fact on Rule 12b-6 motion to dismiss is improper. There's a footnote here. It says the New York Times unsupported an extrinsic assertion that the Wayfair parties had no intention of doing anything in the 2 hours between the publication and deadline for comment. Not only raises a fact issue that cannot be adjudicated on a Rule 12b-6 motion, it is belied by conduct of the Wayfair parties since, including filing the instant lawsuit and releasing voluminous exculpatory evidence. Huh. Gotcha. The email correspondence attached to the declaration of Catherine Bolger, I don't know if I said that right, Bolger, I'm not sure, And those are the emails that I read when they filed that motion to dismiss. They had it as an exhibit. Is not referenced or incorporated into the First Amendment complaint, and the mere fact that the FAC refers to other communications between the New York Times and the Wayfair parties does not permit the New York Times to introduce purported evidence outside the scope of pleadings. Okay. Though the New York Times claims that its promise to wait until noon to publish is nowhere seen or implied in the correspondence. What fucking correspondence were you guys reading? I mean, clearly it was, in my opinion. Tui's emails expressly state that she needed to hear back by noon Eastern, thereby offering to give the Wayfair parties until noon Eastern on December 21st to respond to the inflammatory allegations. 4. The motion should at most be granted with leave to amend. Granting leave to amend is consistent with the liberal standards of Rule 15. And with the Second Circuit's strong preference for resolving disputes on the merits, Patterson versus Morgan, there's that in there. This liberal amendment policy is applied to cases in which statements alleged to be defamatory were privileged under the Fair Report privilege, and when the requisite level of fault was inadequately alleged. The Wayfair parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfair parties respectfully request that they be granted leave to amend their pleading as stated herein. There's a footnote here. It says footnote 30, but I only see... Oh, there it is. The Wayfair parties incorporate by reference the contents of their opposition to the Sloan party's motion to dismiss the FAC and strike Exhibit A. Okay. All right, so that's the body of that, and then we have the exhibit here. It's not even called an exhibit. What is it called? Declaration, right? In opposition to the motion to dismiss. Okay. And Jason Sunshine is one of the attorneys, by the way, if you guys didn't know that. Okay. Anyways. And this isn't super long, guys. I, Jason Sunshine, declare as follows. I'm an associate of the law firm for these plaintiffs. I submit this declaration to annex documents relevant to the Wayfair party's opposition to the motion to dismiss. Annexed as Exhibit 1 is a certified transcript of a video entitled The Waging of an Alleged Smear Campaign Against Blake Lively, published on the website of the New York Times on December 21st and narrated by Megan Toohey. All right. So we're going to see here exactly what the New York Times had said. And we can determine, what we think based on the A, motion to dismiss, and B, the opposition to it. Okay. So this is like I said, a transcript from Megan Toohey's video about this investigation or article or whatever. Megan says, "The movie It Ends With Us, starring Blake Lively, was a huge box office hit, even as rumors spread of turmoil behind the scenes. An illegal complaint Lively filed on Friday. Private text messages and other documents that we've obtained reveal what really happened. A campaign to tarnish Lively after she alleged that Justin Baldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct while shooting the film, a story about breaking the generational cycle of domestic violence, among other allegations. Lively claimed that Baldoni had engaged in improvised and unwanted kissing and made sexual comments to her, and that Mr. Heath had shown her pictures of his wife naked, and that he had watched her while she was topless getting makeup removed, even as she asked him to look away." Jesus Christ. And guys, we know, from what we've seen and the evidence to the contrary, his wife was not naked. Okay. And she invited him to go in there and talk to her while she was topless and getting her makeup done. Or makeup removed, sorry. But she invited him to do that. She's like, it's kind of like how they wanted the meetings in her penthouse. Like, no, we're going to do everything that's convenient for me. But then if I get the perception that, you're doing something that I don't like this moment, I'm going to punish you for it. It's basically, that's how I feel that scenario went. Yeah, no. She had taken her complaints to the film studio, and the men agreed to bring in a full-time intimacy coordinator, an outside producer, and put in place other protections. They also agreed in writing not to retaliate against her, but as the release of the movie approached, they hired a crisis PR manager who orchestrated a smear campaign against Lively. And I'll say this again. People on the internet suss out everything. And they were like, what's wrong with Justin Baldoni? What happened with Justin Baldoni? All this stuff. And so it makes sense to me that given Blake's behavior and their kind of disputes and all that, it makes sense to me that he would hire a crisis PR just to like kind of save his reputation a little bit. It doesn't mean he was initiating a fucking smear campaign. So that in and of itself is like, that's irresponsible not to look into that, if you ask me. But what do I know? I'm just a person with more than 3 IQ points, Megan. All right. The PR expert Melissa Nathan has represented clients including Johnny Depp and the rapper Drake. Nathan came up with a document spelling out her plans, but Baldoni wanted more. That's mischaracterized. Okay. A publicist who had already been working with Baldoni wrote to Nathan, he wants to feel like she can be buried. You know, we can bury anyone, Nathan wrote, but I can't write that to him. In one message to the publicist, Nathan indicated that she had gotten allegations against Baldoni removed from articles. He doesn't realize how lucky he is right now. The whispering in the ear, the sexual connotations, she wrote. I mean, there's just so much. At the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads or theories and generally working to change the narrative. It's impossible to know how much they planted and how much of it was originating organically. Whatever the case, they seized on it and amplified it. Sony, the film distributor, had signed off on a promotion plan that instructed the cast to focus not on domestic violence, but on the uplifting message of the film. Blake Lively, it ends with us in theaters now, so grab your friends, wear your florals, and head out to see it. Again, that was really bad marketing, guys. It was a poor choice. Megan Twohey says, which some online observers said was tone deaf. Yeah, most of them. The team discussed how online criticisms of Miss Lively could help narrative-wise. Emails referred to social manipulation and proactive fan posting. So like PR stuff. Okay. Text messages cited efforts to amplify and boost online content that was critical of Lively and favorable to Baldoni. And within days, they were talking about how the online conversation had shifted. In one message to the publicist, Nathan wrote, socials are really, really ramping up in his favor. She must be furious. And again, so they're there to protect his reputation. What do you expect? It's actually sad because it just shows you how, oh God, this again. It shows you how people really want to hate on women. And we know that Stephanie Jones and Blake Lively both use that same text in their filings. The shift in online sentiment was unusual enough that a digital marketing consultant produced a report that concluded that Lively was being subjected to a targeted multi-channel online attack. Guys, what the fuck is she talking about? I don't know anything about that report. If anybody does, please put it in the chat. Okay. In a statement, a lawyer for Baldoni, the studio, and all its representatives denied the allegations. There are a variety of methods that have long been used to shape public opinion about celebrity gossip columns, tabloids, strategic interviews, but this story reveals a new playbook for waging a far-reaching and largely undetectable smear campaign in the digital age. You're a cunt for that, Megan. I'm sorry, but like, if you... The only thing that she wrote in here after getting, or she said in here apparently after getting that whole statement was they denied it. And then they're like, but it reveals a new playbook. Okay, so why didn't you dig into that a little more? Why didn't you give them more time? Why didn't you care enough to share both sides of this story? You had the means. God, you suck. All right. And then they have timestamps here for that. yeah, that was it. And I think we'll have to ask my friend Omar if he feels like this motion to dismiss is still going to be granted. I know Omar really felt like the New York Times was going to get their motion granted, like it was going to be thrown out. So I want to know, after reading that, when he has a chance to read that, if he's going to feel the same way or not. So we'll see. Right now, I'm going to ask you guys to do me a favor. We're going over to my friend, the expert, and send him lots of bacons and robots, the Bacon Bot Army incoming. Send him lots of love. Let him know that I sent you. And I will finally go to bed soon, I hope. Because I was not expecting to do this tonight. But I noticed that Justin's attorneys will sometimes file stuff late at night like this. So, all right. I'll probably do a little short recap video of this to schedule it for tomorrow morning. And like I said in the earlier stream, guys, you got lots of stuff to cover this weekend. I'll be doing that stream tomorrow night, I think, where, crazy Blake Lively fans are now trying to have me fired from my job, even though they want me to do a different job because they don't know that this isn't how I make my living. So there's lots of crazy stuff going on. What we're going to do is I'm going to roast the shit out of these trolls. And half of any super chat money or donation that I make, I will donate to No More, the charity that Justin worked with, or just any charity that's like near and dear to him, because I feel like that is the best way to kind of make a good thing come out of these awful trolls. So yeah. And if any of them are watching right now, I just want you to know that I still have all my chins, and thank you for pointing it out in my DMs. All right, guys. I'll see you tomorrow. Bye. Don't forget to like.